Hello everyone, तो कैसे हैं आप लोग? So today we'll learn what is section 482 of the CrPC that deals with inherent powers of the High Court. So if the video will help you a little bit, please do like and subscribe. So what do you mean by inherent? Inherent means something vested, inbuilt with the High Court. So the section says nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this code or to prevent abuse of the process of any court or otherwise to secure the ends of justice. So section 482 can be used for what? For three purposes, that is to give effect to any order, to prevent abuse of the process of any court or otherwise to secure the ends of justice. Please do mark the underlined words. It will be explained afterwards. So the exercise of this power of the High Court under section 482 is an exception only and not the rule. So no new power is conferred on the High Court. Only it has the inherent power. So now let's see the conditions which are to be fulfilled for the applicability of section 482. Firstly, alleged injustice should be grave and not of a trivial nature. It should be intense, clear and doubtful, and there exists no other provision of law by which the party aggrieved could have sought relief. So this section is just like the section 511 of the IPC, where it says that attempt to commit offences punishable. So if there is no express provision as to attempt of any offences, then that person will be uh, charged and convicted for the attempt of such under section 511. Like attempt to theft, there has been no express provision for attempt to theft, but he can be convicted for attempt to theft under section 511. Like such 482 is in CRPC. If the court sees that there is no express provision as to do justice or give relief to the aggrieved, then it can use the power under this section to grant him such. So now let's see the circumstances under which the inherent power may be exercised. A, B, C. A clause says that to give effect to an order under this code, to prevent abuse of process of code, lastly to otherwise secure the end of justice as given in the section. So what do you mean a process? Process means anything done by the court. It is upon the court to take decision as to what will come under the process. So abuse of the process of code means anything which is malified, frivolous or vexatious according to the code. So the term in which the prevent abuse of the process of any code. So any code means a code in relation to the High Court of that state and not of any other state. Example, Odisha High Court cannot quash any proceeding in the Kerala High Court. Odisha High Court can quash the proceeding in the courts of jurisdiction of Odisha only. So what is secure ends of justice? It is based on the principle ex debito justitiae. That means to do real substantial justice. Example, interference by the High Court in the matter of police investigation is permissible only if non-interference would result in miscarriage of justice. So there police can interfere. Sorry, High Court can interfere in the police investigation. So now let's see the general principles to be followed while exercising inherent power. So if the question will be what is the general principle to be followed while exercising inherent power of the High Court, then we have to write these three. Firstly, no exercise of 482 power if there is a specific provision in the code for the matter referred. Like the example I said of 511 of IPC. Secondly, it should be exercised very sparingly and with caution. Third, it should not be exercised as against express bar of law provided. Where it is express bar of the law, then there it shall not be exercised. So the question may be in which stage the inherent power can be exercised. So the answer is inherent power can be exercised at any stage of the criminal proceeding. Suppose the appellate court can exercise in appeal, revisional court also exercise in revision cases. So the question may be when the complaint can be quashed using the inherent power under section 482. The answer will be like this. Suppose where the complaint does not disclose any offense, it is frivolous, vexatious or oppressive. It is only an exception, not as a rule. Remember, 482 section can be used only in exceptional cases and not as a rule. When there is clear abuse of the process of court, then the inherent power can be used, and the power shall not be used to stifle or scuttle a legitimate prosecution. That means to restrain or obstruct or harass the prosecution. So the next question may be, in which cases the inherent power of section 482 can be used for quashing of a charge? The answer may be, if evidence which prosecutor proposes to adduce to prove the guilt of the accused, even if it is fully accepted, even if the evidence is fully accepted before it is challenged in cross examination or refuted, it cannot show that accused has committed the alleged offense, and there must be a fundamental defect in the charge for it to be quashed. Now let's see quashing of cognizance. So cognizance can be quashed only when uncontroverted allegations in the FIR or the complaint do not disclose the commission of any offense. Cognizance when is taken by magistrate only upon a police report or complaint. So if there is any uncontroverted allegations in the FIR complaint which do not disclose any commission of offense, then the High Court can exercise the section 482 inherent power to quash the cognizance. Now the question may be, does any court other than the High Court enjoy inherent jurisdiction? So in a case A.S. Goraya versus S.N. Thakur, the Supreme Court held that subordinate courts do not have inherent powers like the High Courts. But in the case of Minu Kumari versus State, the Supreme Court held that all courts, whether civil or criminal, possess in the absence of any express provision as inherent in their constitution all such powers as are necessary to do the right and to undo a wrong in the course of justice. So subordinate courts and all criminal courts have the inherent jurisdiction according to this case law. The principle is, when the law gives a person anything, it gives him that also without which it can't exist. So this is all about section 482 that I covered. So if it would help a little bit to you, then please do like and subscribe the video. Thank you everyone.